This module focuses on the proposed amendments to the additional facility rules.
The proposals would update the additional facility in a number of ways, which we will review in this video.
First, the proposals expand access to the additional facility proceedings. For example, the proposals would open the additional facility to regional economic integration organizations, or REIOs, such as the European Union, so that they could become parties to additional facility proceedings. This addition reflects the recent trend of REIOs entering into investment agreements in their own right and would enable them to be a claimant or a respondent in a proceeding. For the purposes of the additional facility, an REIO is defined as an organization constituted by states to which they have transferred competence in respective matters governed by these rules, including the authority to take decisions binding on them in respect of those matters. This definition is used in other international instruments addressing REIOs and has been adopted here for consistency.
In addition, additional facility arbitration and conciliation proceedings would be available to settle legal disputes arising out of an investment where none or only one of the parties has an ICSID member state nationality. In fact, this possibility of additional facility arbitration between a non-convention state and an investor of a non-convention state is already offered in some IIAs, so the proposed rules would give effect to these agreements.
The proposal also expands access to the additional facility in terms of subject matter of the dispute. In particular, the proposed rules provide that arbitration and conciliation under the additional facility would be available when there is a legal dispute arising out of an investment. The current rules require a consideration of whether the dispute arises directly out of an investment, while the proposed rules would remove the qualification of directly. This means that the investment criterion would be determined solely by reference to the relevant instrument of consent. In other words, the International Investment Agreement, law, or contract. At the procedural level, the proposed rules for arbitration and conciliation under the additional facility are similar to those proposed under the ICSID Convention.
With regard to mediation and fact-finding proceedings, the requirements for submitting a dispute to these categories of proceedings are simple. Fact-finding and mediation are available for disputes pertaining to an investment between an investor on one side and a state or an REIO on the other side, regardless of their membership in the ICSID Convention. It's important to note that parties can avail themselves of mediation and fact-finding proceedings on a standalone basis or in conjunction with arbitration or conciliation proceedings under the ICSID Convention, the additional facility, or in fact, in any circumstances where they might help resolve the dispute.
Finally, in line with the modernization objectives of the rules amendment process, the additional facility rules simplify the registration procedure. This is done by deleting the requirement of approval of access under the current rules, a requirement which currently has to be complied with before a party can file a request for arbitration. Instead, the proposed rules replace this requirement with a one-step approach, i.e., screening at the stage of registration under each set of rules. The proposed test for registration is to check that the information provided in the request is not manifestly outside the scope of Article 2.1 of the Additional Facility Rules.
We hope that you find this video useful. For more information, please visit the ICSID website's Rule Amendments page, which is available in English, French, and Spanish.